Hi everyone, Anthony Antonio, Northamptonshire luxury property expert, and this week I'm delighted to be bringing you some very good news from the Court of Appeal. Good news for landlords, that is. As many of you are aware that as part of the 2015 Deregulation Act, one of the conditions was that you are obliged to provide a tenant with a gas safety certificate before they move into a property. Otherwise, you void your right to use a Section 21. In fact, the government were very arrogant about this, and they were quoted as actually saying that once landlords miss this boat, there is nothing that they can do to rectify it, leaving landlords in no man's land. I've been in that position myself, where a tenant, friend of a tenant, moved in while I was abroad. The tenant then moved out, and then the tenant who slipped in while I was away then used that as an excuse to literally drag me through the courts for a long time. And I'm sorry to bash solicitors again, but I'm sorry guys. You are very happy to take a large fee from people for filling in a statutory fast track for a Section 21. That any deviation from that, and my personal experience was this could happen, that could happen, I don't know about this, I don't know about that. I went through solicitors over 3 years until I found somebody competent who actually came up with a strategy that worked. Now you do have a window to rectify this if you are also in that unfortunate position. However, going forward, once again, this is advice from a barrister who did know what he was talking about. Before you allow a tenant to move into the property, you will itemise everything: your gas safety certificate, your electrical safety certificate, a statement that there are CO2 monitors and so on, fire smoke alarms in the property, the energy performance certificate, but you will not ask the tenants to sign once at the bottom, because that gives the opportunity for leeway. They will itemise and sign a written acknowledgement of receiving each one. They will sign it, they will date it, and it will be witnessed, so that there is absolute clarity that they received each one before they moved into the property. Unfortunately, landlords have been made to be the bad guys. I don't think a lot of people realise that there are many landlords out there who buy properties as long-term investments, and what is the reason that they give a 1-year lease? The reason is, as people may not be aware, that is actually a condition of most buy-to-let lenders. I'm sure there are many landlords out there who would be happy to have the right tenants and give them under certain conditions a lease of 2 years, 3 years, 5 years or more, with incremental increases in rent to keep up with inflation and so on. It is not down to the landlord, it is down to the lenders. And in many instances, landlords are actually trying to evict tenants because they decide that they want to sell the property, because the lenders are so funny about tenants being in a property. They are actually the cause of the problem most of the time, because if the tenants are in a property, they're happy and they're paying, why would a landlord want to evict them, even if he's selling the property, because another landlord would be happy to buy the property with them in situ? It is the lenders that are the problem. Also, local authorities who advise tenants who have been given a Section 21 to remain in the property until they are evicted. So the local authorities throughout the country who instigate this are actually turning a perfectly good tenant into somebody who's going to fall foul of the law and be evicted because this is the advice they give them. But a few years later, since they've been doing this, they have only exacerbated the problem, because for every action there's a reaction, and landlords have become more and more cautious about who they rent to or how they rent to, and many of them have indeed taken their properties out of the assured short hold lease category and either gone for either gone for short stay or HMO or whatever the case may be, because of these problems. So the local authorities who are acting, purporting to be acting on behalf of the tenant, have actually made the problems much worse. So anyway, this is very, very good news. The whole written article, there's a link to it below, link to my blog with the full article if you haven't read it. If there's anything that you wish to know with regards to landlord law, I'm not an authority on it, but I can assure you that whatever could possibly happen has probably happened to me, so I can relay my experience to you and point you in the direction of somebody who can actually help, not somebody who's going to charge you a fee to just look at your case and then give you excuses. Sorry guys, but realistically, I've never ever seen so many solicitors bury their heads as I have when I had a tenant in a house playing this card intentionally to avoid leaving my own home, which is where I am now, which I was desperately trying to get back for my own use so that I could live in. Anyway, please feel free to contact me with any questions you may have at any time, no charge. I'll just give you my advice and my experience, and you can do with it as you wish. See you in the next video.